a police officer and which has been granted as against a private person seeking a prior approval, madam. So just Your Lordship may kindly see section 17A for a moment. My lord. It says that no police officer shall conduct any inquiry or investigation to any offence alleged to have been committed by a public servant under this act. Then, my lords, where the alleged offence is relatable to any recommendation made or decision made by him, taken by him, by such public servant in discharge of his official functions or duties with the previous approval. Then, my lord, second proviso is important, my lord. Provided further that the concerned authority shall convey its decision under this section within a period of 3 months. So, therefore, my lord, the condition precedent for this is, my lord, there should be a preliminary inquiry done by an investigating officer, my lords, which has to be placed before, given along 17A, my lords. The reason is this. When
to get clarification, sorry. Now, are you suggesting that prior to 17A approval being granted, there should be a preliminary inquiry?
As held by Lalit Kumari, that is what.
Equating 17A, if you're equating 17A order to an FIR, preliminary inquiry is necessary.
If your Lordship sees my lord, Lalit Kumari clearly says, my lord, insofar as cases of corruption cases.
Not true. Para 120.1.
1 and
6 postulates there.
6 postulates. We come in clause D, C and E, my lord.
Yes.
If we come under clause C and E of Lalit Kumari, my lords, it is mandatory that a preliminary inquiry is done. I'm not talking about inquiry as contemplated under 17A. What I'm saying is pre-17A. Your Lordship may kindly see
pre-17A, all the 3 circumstances, inquiry, or investigation.
I'll be able.
For all the 3, you need 17A approval.
Correct.
Where is the question of the 17A, prior inquiry under 17A without compliance with 17A?
So, Your Lordship may, I'll take Lalit Kumar. Your Lordship may kindly see.
Please take para 120.6,
Please,
2014-21, page 1. Yes.
This court written submission, I've just culled out the relevant paragraphs. Photos.
ಅದು ಓದಿ ಹೇಳಿ ತೊಂದರೆ ಇಲ್ಲ 14 2 SCC page 1 para 120 go.
Your Lordship may kindly turn to page 61, my lord, of my at page 62 or 61 it starts.
There is a list of other written.
No, just a notes. Instead of going to all the judgments, my lord, whichever judgment I'm relying upon, I've culled out the relevant paragraphs, my lord.
All right.
As the Lordship pointed out, my lord, that 120.6 D and E, my lord. 120.6 as to what type and which cases preliminary inquiry is to be conducted will depend upon the facts and circumstances of each case. The category of cases in which preliminary inquiry may be made are as under.
So, D and D,
where the case is abnormal delay in latches. This is a case of 22 years, more than 20 years, my lords. 1998, according to them, my lords, is a case of denotification. Assuming for. No, I'm saying it is a case
you're
where.
Thinking to that. Yes.
Please.
Where there is abnormal delay.
Abnormal delay. So
then you may be just.
Please. So.
All right. Yes.
So therefore, my lords, coming under the corruption case and under abnormal delay, my lords. The question is preliminary inquiry is mandatory. So therefore, my lord, that is why, my lord, the language used, first portion, no police official shall conduct any inquiry or investigation, so and so, as committed by a public. If your Lordship read the SOP, my lord, which will give further more clarity. Your Lordship may kindly take volume 1.
Page 703.
Please, my lord.
706, yes.
That's the crux of the whole thing, my lord.
Volume 2, 706.
Absolutely, my lord.
Yes.
Annexure M, my lord.
Yes, sir. SOP of the Government of India on 17A.
Please, my lord.
Yes, sir.
So, the private person cannot be put in a higher pedestal than a police officer, my lord. What, assuming, my lord, the preliminary inquiry has to be done. This is what the crux of the whole 704, my lord. So as to standardize and operationalize procedure with a view of achieving uniform and effective implementation for prior approval processing under 17A of the Act. They set first stage processing of information received by the police officer. In this case, my lords, this has not been done. Then, my lord, 705, what as your lordships were pointing out, standard operating procedure for handling information in respect of a public servant alleging offense under the PC Act, seeking of previous approval for conduct of inquiry or investigation under Section 17A. Then, my lords, clause 2, it may be emphasized that the provisions of Section 17A stipulates a mandatory requirement for a police officer to seek previous approval for conducting so and so, so and so, so and so, alleged to have been conducted. The police officer upon, this is the requirement, 3.2.
No, that would bear reference only to a crime registered before a police officer. No, that would not cover private complaints. Private complaints was a concept that was evolved by this court in G.V. Ashok, so that SOP won't help.
No, it will help. The reason is it is a case of private complaint before the police officer.
Where?
Here is a complaint registered before a police officer. That I'll come to 154, 173, 114 much later, my lord. Here is a case where a complaint is given to a police officer, sufficient time is not given, they jump the gun and apply for judgment in Dr. Ashok's case.
Where is jumping of the gun here?
Because, my lord, I'll come to the facts with regard to 150. Why? Preliminary inquiry, what is stipulated, that is 15 days to 6 weeks. They don't wait for that. Then they apply for 17A for compliance of Dr. Ashok's case. So therefore, my lords, what has to be read is the preliminary inquiry. Ultimately, my lords, the governor does not do the preliminary inquiry. He only grants prior approval. In this case, what has happened, my lords? He sits as a preliminary, does the preliminary inquiry. That is hearing the complainant for 1.5 hours, according to them.
All right.
Then issuing show cause notice, seeking clarifications, seeking reply. So therefore, my lord, that is the sole jurisdiction of the police officer as per the SOP and as well as the judgment of this.
And even as per 17.
As per. I'm born into it. I'll just point out, to highlight a few aspects in this SOP. Your lordships have read, my lord, just to.
Sir, you can.
Then clause 4, my lord, page 705, 3.1, Roman 4, Roman 3, specific acts of commission or omission attributable to such public servant, whether such acts are relatable to the official functions or duty by the such public servant, specific to the office post held at the time of commission of the alleged offense, specific recommendation or decision taken by the. My lord, all these aspects are very crucial because this says when the police officer or the investigating officer seeks for sanction, these requirements has to be placed before the competent authority. Then, my lord, page 706, that Roman 4, the proposal of the police officer of the appropriate shall contain the following information. So, therefore, my lord, the proposal is the formation of an opinion by him prima facie that cognizance of this case has to be taken. 4.4. The appropriate officer of the appropriate rank shall make a proposal of to the appropriate government, as such case may be through a single window process as laid down by these SOPs, and shall ensure that the proposal is in accordance with the requirement laid down in the checklist, enclosures, clear, legible, and authenticated documents as may be required. Separate proposal shall be submitted for. This is important, what your lordship just said. Separate proposal shall be submitted for inquiry or investigation as the case may be. Your lordship may now kindly see the page 707, my lords. What it says, the incomplete proposal should be sent back by the competent authority back to the investigating officer. Then so therefore, what is the approval which speaks previous approval is the proposal sent by the investigating officer. In this case, my lords, or if I'm giving a hypothetical, tomorrow all citizens or any busybody gives complaints against everybody, my lords.
That's precisely why I wrote prior approval is needed.
Dr. Ashok has said because it first compliance of 154 prior approval, then comes the complaint. Here, my lords, what has happened, as I said, 154, here, my lord, even what is applicable to a police officer, the same procedure ought to have been applied. The competent authority to
Followed by the governor?
no, governor ought to have asked the private party to say that give the information with regard. There are two aspects, my lord.
So much of information is given.
No, with regard to the format, allegations have been given. My lord, there are two aspects. One is formulation of an opinion can be done only by the investigating officer, not by a private party. His opinion will not make any difference. So therefore, there are two stages. One is you ought to have given as per the requirement of law. Once having received it, my lords, the competent authority does not do the preliminary inquiry. It is the competent authority could have asked, as required under law, the investigator to give the information. He would not, in case of preliminary inquiry was undertaken at the early stage, please enclose, my lord. Then whether any criminal offense. So therefore, my lord, this is what is approved under 17A, which goes to show that there is an application, preliminary inquiry done, there is a proposal, there is a report, and application of mind is to this. Therefore, my lord, my submission is on point of law is, my lord, is that the allegation of the complaint which was sought for under 17A ought to have been returned. Second aspect is, my lords, if it was accepted, preliminary inquiry information, instead of asking the complainant or the show cause not having issued to the petitioner, it is information ought to have sought for from the investigating officer in terms of 17A or the SOP issued by the central government. That's my first submission. Therefore, my lords, I'm not going into as to the rest of the process. The main thing is you ought not to have entertained the application itself. As your lordship initially pointed out, my lords, 7 late preliminary inquiry. I bow down to that. What is requirement of Lalit Kumari and your lordship's line of judgment, my lord, that preliminary inquiry is mandatory, is what ought to have been followed. Your lordship may just. The next aspect is, my lord, insofar as recommendation is concerned, next is the heart of the whole thing is, my lord, is whether there is any recommendation or decision made. My lord, it applies both ways. What ultimately the argument will say, I don't need the protection because I'm not in any other case, if protection, if we are seeking, saying that it does not come within the 17A, the protection under 17A goes.
No, if you do not offense under the PC Act,
PC Act, that is under.
All right.
So therefore, my lord, what is crucial, my lord, is that offense has to be relatable to decision, recommendation, and the office head. The lordship may kindly see 2-3 judgments on those lines, my lord. I just reproduced it in my compilation. I just would like to take a lordship to the relevant paragraph, my lords. Your lordship may kindly turn.
Yes.
This is Nara Chandra Babu Naidu versus State of AP, my lord, 2024 ACC online. I'll just read para 3 just above that, my lord. In this context, the current case, these definitions underscore the importance between alleged corrupt act and the official recommendation or decision. Linking the interpretation reinforces the protective intent of Section 6. Servants are shielded from unwarranted investigation from acts not directly connected to their official duty. The para 55, in para 4, Section 17A has the following 4 more facets. Inquiry or investigation of the offence under PC Act. Alleged offence should be related to the recommendation made or decision taken by a public servant. Such recommendation made or decision taken by the public servant should be in discharge of his official functions or duties, and the previous approval of the authority is mentioned therein. My lord, in fact, in B.S. Yedurappa's case, my lords, case of denotification, the division bench of this court, my lord, in para 31, I've just quoted that I said, even otherwise, the order of denotification passed by the petitioner, in this case, it's not passed by the petitioner, para page 31, in the circumstances discussed above, cannot be construed as any recommendation made or decision taken by the petitioner in discharge of his official duty so as to attract section 17A of the PC Act. So, my lords,
Yes.
this is, and next, my lords, even the Gujarat High Court also has held on identical. The word relatable is an adjective. The legislature in its wisdom has used adjective relatable to connect the offense to a recommendation made or decision made. Therefore, such approval shall be required when the offense is associated with and connected to a decision taken or recommendation made by a public servant in discharge of his official duty or function. Use of the adjective relatable to the offense is considered opinion of this court, limits and restricts the offense to be associated with and connected to a decision taken or a recommendation made by the public servant in discharge of the official duty or function, and therefore can't be extended to all offenses under the PC Act. The same is Madhya Pradesh High Court, para 6.3. Section 17A is attracted only when the offense alleged under Section PC Act relates to the act of recommendation made or decision made, but is not attracted when the offense relates to demand or acceptance of bribe, taking to an illegal gratification or disproportionate.
No, that's why trap cases gate is not applicable.
Please, my lord. Then last, this Kerala High Court judgment, my lord. Ultimately, my lord, that is why the SOP becomes very, very important, my lord. The checklist gives for the purpose of formation of opinion, para 9. The most crucial part of Section 17A provides that the previous approval is required in relation to an inquiry or investigation into an offense alleged to have been committed by a public servant under this Act, where the alleged offense is relatable to any recommendation made or decision taken by the public servant. It seems that the above part of the section is most crucial part of the section, since imposes a rider that otherwise the absolute power under Section 17A, so and so, so and so, and so and so, in every act needed prior approval.
Yes.
My lord, next, one other aspect, my lord, if your lordships kindly turn to page number 13, my lord. This is with regard to Yashwant Sinha versus CBI, with regard to preliminary inquiry, my lord. Just going back.
3.
Page 13, my lord.
Yes. Sirajuddin is followed.
Sirajuddin is followed, Yashwant Sinha and Prabhat Kumar Dobe, my lord. The reason I'm using the preliminary inquiry has to be, so even in case of Shrirupa, my lord, what the courts have said that while doing the investigation officer should have credible evidence based on which an opinion is formed by him, the purpose of seeking of prior approval under 17A.
Yes.
So therefore, my lords, in this case, my lords, I mean,
According to you, the petitioner has not done anything that is relatable to a decision taken or a recommendation made.
I'll slightly modify it. What is not there in this is, my lords, it is only an investigating officer who can give.
No, I'm only asking a simple question.
Please, my lord.
According to you, the petitioner has not done anything that is relatable to it. Sir, petition. You're appearing for the complainant?
No, your lordships are saying petitioner
No.
is accused.
Petitioner is accused. That is what I'm saying. According to your suggestion is that petitioner has not taken any decision or recommended anything that would become an offense as is that your submission?
Please. No, your lordship.
No.
No, I'm not on that. That's the legal position, my lord. In order to invoke 17A, that is a condition precedent, my lords. As your lordship pointed out. Here, I'm slightly one step further to entertain